Judge N.D. Shukri Kamal, who was born on 30th June 1971 in Kodilpur, Kodagu district. His Lordship completed his BA LLB at Vidyavardhaka Law College, Mysuru, and emerged as a rank holder. He enrolled as an advocate with the Karnataka State Bar Council on 5th August 1994. During his practice, he appears before the High Court of Karnataka, City Civil and Sessions Court, Chief Metropolitan Magistrate Court, and Debt Recovery Tribunals in Bengaluru, primarily handling civil, criminal, constitutional, labor, arbitration, revenue, and work of matters. Justice N.D. Shukri Kamal was appointed as the additional judge of the High Court of Karnataka and took oath on March 17, 2021. His Lordship was made a permanent judge on September 30, 2022 and is currently serving as Administrative Judge of Koppal District. Throughout his tenure, he has delivered several landmark judgments. One notable judgment saw Justice Kamal alongside Chief Justice Petitioner crush a public international litigation filed by residents of HBR Act in Bengaluru, who opposed the use of residential property as a prior hold. His Lordship firmly rejected the arguments that offering priors posed a risk and imprisoning that is not a threatening activity. In another significant judgment, his Lordship ruled that under the Bombay School of Inheritance, his sister is entitled to share in succession if it opened prior to 1956. Justice is a great asset to the legal field, known for his profound legal acumen and dedication to justice. Thank you.
Respected judges, the matter that is listed before the bench is Khawateen or Saman Adhikar versus the Union of Aranya Raj and others. The petitioner, Team 29, and the respondent, Team 3. If your Lordship are pleased, shall we commence the proceedings?
Yes.
Counsel seeks permission to approach the dais. Greetings to the Honorable Bench. This is counsel for the side of petitioners in the case of Khawateen Samanadikar and others versus Republic of Aranya Raj. With your Lordship's permission, if your Lordships are already aware of the facts about this case, should I proceed with the issues that have been raised in the petition?
Make it facts as well.
Indeed, your Lordships. So, in this case, we have raised 4 fundamental issues regarding personal laws and the Uniform Civil Code. Your Lordships, we are before this honorable bench to contest 4 issues whether the forms of divorce as prescribed under customary laws are violative of the provisions of Constitution of Aranya Raj. The second issue before us is about the constitutional validity of Uniform Civil Code. The third issue is regarding the succession inheritance laws which are included in the personal laws. And the fourth issue calls into question the legitimacy of living relationships in the state of Uttarakhand. Your Lordships, for the sake of convenience, I will be dealing with issue number 1, which is pertaining to divorce laws under personal laws regarding divorce, succession and inheritance, which is issue number 1 and 3, while my co-counsel will be dealing with issue number 2 related to UCC and living relationships. With your Lordship's permission, I would like to start with the first issue.
Before that, His Lordship asked you to tell us what the facts of the case, a brief summary. That's what is asked you to do.
Indeed. Your Lordships, in the state of Aranya Raj, which is a vibrant democracy, here a lot of people from different communities, different religions, practice and exercise their rights under the Constitution of Aranya Raj. We have been given 4 different situations in this, where the different high courts have received petitions for the violation of fundamental rights related to personal laws. In one such situation, a Muslim woman has been denied of her right to acquire inherit property. inherit property from her husband. I beg your pardon, Your Lordships. In the first situation, the Muslim woman has been, the husband has pronounced talaq-e-hasan, which is the matter in question, towards this lady, and she has approached the court for violation of her right, challenging the constitutionality of talaq-e-hasan. In the second matter, which is related to a woman from Nishi community, Nishi tribe, belonging to the state of Arunachal, her succession rights have been challenged here. After the father's death, the property was inherited by both the sons, and the mother and the daughter were kept out of the succession. The third matter at hand is that of a couple who has spent 7 years in a living relationship without legally registering their marriage. And their relationship, post the husband's death, the property was taken over by the husband's parents. And the woman was not given her right to inherit the property from her husband. In the fourth case, the state of Kedar, in this Republic of Arunachal, had enacted a law to the effect of UCC, Uniform Civil Code, which has been challenged on the grounds of its constitutionality. Your Lordships, with your permission, I will start with the first issue, which is related to the forms of divorce as prescribed under customary laws, which are violative of the provisions of Constitution of Arunachal. From the petitioners, Your Lordship, our humble submission is that all these personal laws provide for certain forms of divorce which are discriminatory on the grounds of right to equality under Article 14, right against discrimination on the grounds of sex in particular under Article 15, and right to life and liberty, right to life and dignity under Article 21. Starting with the first fundamental right, right to equality, which is an essential and the first fundamental right which is given by our Constitution. Your Lordships, there are two facets to right to equality. First one being equality before law, and the second one being equal protection of laws. First one, while has a negative connotation, the second one gives a positive connotation. In this particular case, men and women, talaq-e-hasan is a practice which is prevalent in the Muslim community. While this practice is not given, the right to pronounce talaq is not given to Muslim women. At the same time, a Muslim husband, without giving any legitimate grounds for pronouncing divorce, can exercise this right. There are other forms of such divorce which petitions would which council would like to draw your attention to, like ila, zihar, which also give unilateral irrevocable rights to the Muslim husbands to pronounce for divorce, while Muslim women are denied this right. So, I beg your pardon.
What is the source of this right for this practice?
Your Lordships, talaq-e-hasan and talaq-e-hasan and all other forms derive their legitimacy from Quran, Hadith, and there are other religious texts which support these rights.
What is the latest on that?
Your Lordship, under Shaira Bano judgment, talaq-e-biddat, which is commonly known as triple talaq, was held unconstitutional on the grounds that it does not form a part of essential religious practices.
What about other forms of talaq?
Your Lordships, in the same judgment, the judiciary dwelled upon the question of checking the constitutionality of talaq-e-hasan, where it was held that it forms a part of essential religious practices, which is because it is coming from Quran. But our contention here is, Your Lordships, despite it being a part of essential religious practices, it is still violating the fundamental rights of a section of citizens, which is essential religious practices cannot be the sole ground on the basis of which fundamental rights of these women can be taken, which is why we have come before this court to challenge the law.
How do you decide it does not form fundamental core essence of a religious belief?
Your Lordships, we are not contesting that it is not a part of the essential religious practice. Our contention here is that although it is part of, it must be mentioned in Quran, it must be coming from habit, it must be coming from other sources, legitimate sources of the religious practice, but they are violative of the principles which have been laid down in our constitution. When we say that this country is governed by those very principles, Constitution of India, Constitution of Aryan Raj is the grand law. That is the highest law of the land.
How do you read 26 with these principles?
Your Lordships, 25, the right to religious freedom, to profess, propagate and promote religion, is subject to certain conditions, such as it can be public order, health or morality. Also, this particular section has been subjected to the fundamental rights, which is part 3 of the Constitution. So if any of these provisions, if any of these religious rights are in violation of the other provisions of part 3 of the Constitution, which is right to equality, right to life and dignity, then they should be held unconstitutional. If we talk about 26, that gives religious institutions or denominations the right to exercise their religion. Here, the matter is about individual personal rights, and it's not the religious denomination that we are challenging or contesting. Your Lordships, moving on to the equal protection of laws, women not just are discriminated with regards to men, but also women as a group of people in the state of Aryan Raj. From other communities, while the Hindus are covered by Hindu code bills, all these communities, women from communities such as Buddhists, Jains, Sikhs, including Hindus, are all covered by Hindu code bills, and they are given proper grounds for pronouncing divorce. While Muslim women do not have that power to exercise.
You have the Muslim Marriage Dissolution Act 1956,
Your Lordships,
which is grounds for women to ask for divorce.
Indeed, Your Lordships.
Also have been given power of talaq-e-tazweez.
Your Lordships.
It is not sufficient to take an interest. There is a discrimination there. Is there any law governing right of a Muslim married husband to seek for divorce under legislation?
Your Lordships, I will start with 1939 Act, Dissolution of Muslim Marriages Act. Your Lordships, although it specifies certain grounds, but since there are practices like, there was practice like talaq-e-biddat which was prevalent in the community, and now since we have talaq-e-hasan or hasan ila zihar all in practice, Muslim men are not resorting to any other means. Muslim women, because of the lack in literacy in the community, because of disprivileged backgrounds that these women are in, the situations that these women are in, unfortunately, literacy is less, awareness is less. Hence, it's very difficult for a Muslim woman to seek divorce under the judicial process. It will simplify the process if in the personal laws we could find certain areas where the Muslim women either are given those rights, or else the areas which men are using to exploit women unnecessarily without any legitimate grounds are struck down by the Constitution, which happened in case of talaq-e-biddat. That is what our humble submission is, Your Lordship. Regarding khula, Your Lordships, although women can offer some dower amount to purchase their right to seek divorce, but that also takes away from them the right to custody of children. So that is again unfair. Also, the second thing being, if the husband renounces or if the husband chooses not to accept the dower, then khula is of no use. Although that gives the woman the power to call for divorce, she is still subject to how whether a husband accepts the divorce or not. Your Lordship?
Yes.
Your Lordship, with your permission, moving on to the second sub-issue. But it also fails the test of manifest arbitrariness, which was again laid down in the famous Shaira Banu case. Your Lordships, when there is no substantial ground for for bringing out legislations or for bringing out rules according to which the society has to work. And these legislations end up discriminating against a certain bunch of society or a certain section of society. All those are to be struck down by the Honorable Court. I would like to quote the landmark judgment of E.P. Rebuttals versus State of Tamil Nadu, 1974, for SCC page number 3. Your Lordships, and I quote, this Honorable Supreme Court held that equality...
Produce the citation in your memorandum? Which page number?
Your Lordship, it's page number 17 of the petitioner's memo.
Yes. Page number?
17. 17.
Paragraph?
Paragraph 15, Your Lordships.
Yes, read.
In third line of the paragraph, Your Lordships, in E.P. Rebuttals versus State of Tamil Nadu, it was held that equality is a dynamic concept with many aspects and dimensions, and it cannot be cribbed, cabined, and confined within traditional doctrines. From a positivistic point of view, equality is antithetic to arbitrariness. Your Lordships, this...
The present fact of the case.
Your Lordships, when we ask for equality, there cannot be arbitrary grounds. I beg your pardon, Your Lordship.
How do you apply precedent?
How do you apply precedents? Your Lordships, the Honorable Court has the soulful...
What are the basic things you apply for precedent?
Your Lordships, precedents are sound.
Cite the judgment of a higher court. What are the element that you have to bear in mind when you're citing the judgment?
Your Lordships, the first requirement...
Facts of the case and Roy case.
I beg your pardon, Your Lordship, I can't recall that at the moment. Okay. Your Lordships, as you asked, talked about manifest arbitrariness. Something that is done capriciously, irrationally, without determining principle, are all the grounds on the basis of which you say that it's manifestly arbitrary. There is no substantial ground for this particular law to be enforced. If there is legitimacy, if there is something that can prove that men of certain community are given these rights or these unbridled powers on the basis of these set standards, then it will of course be tested on those grounds. But then if you do not have legitimate grounds for, if the precedents have been followed irrationally without any ground, then it has to be seen in that light. It has to be challenged on the grounds of basic tenets of the Constitution.
Yes.
Your Lordships, not only does it violate fundamental rights, it's also against the principle of natural justice. Our nation works on the principles of equality.
How do you say
justice.
The case of Talaq-e-Ahsan or Talaq-e-Ihsan?
Your Lordship, Talaq-e-Hasan.
The religious scriptures, how does it has to be proceeded further?
Your Lordships, in Talaq-e-Hasan, the man can pronounce talaq in consecutive 3 cycles.
Which provides for that. What is the modality of it? What is the precaution to be taken to pronounce it?
Your Lordship,
Is it just at the drop of a hat he pronounces, or is there a procedure prescribed for it?
No, there is a procedure associated with it, Your Lordship. That procedure is within 3 cycles, lunar cycles or menstrual cycles of the woman, the husband will pronounce talaq, the first instance, and then he'll have to wait for another month. Again, a pronouncement of talaq in the second lunar cycle.
What's behind this?
Your Lordship, the purpose behind this is to give them time to reconciliate.
What's principle of natural justice?
Your Lordship, this gives them the time to reconciliate, but then that is usually the woman, once the husband has already decided that he wants to talaq without any reason, without any ground.
You can go next.
Your Lordships, indeed. On the principles of Article 14, Your Lordship, discrimination, which clearly states, prohibits the discrimination on the grounds of religion, race, caste, place of birth, and specifically in this case, sex, is to be condemned and is to be struck down by the Honorable Court. The third sub-issue, Article 21, Your Lordship, right to life and dignity. Muslim women, right of, Your Lordships, here I would like to cite a landmark judgment by this Honorable Court, Francis Corelli Manin versus the Union Territory of Delhi. And I quote, "No person shall be deprived of his life or personal liberty except according to procedure established by law." The Supreme Court has repeatedly observed that expression life in Article 21 means life with human dignity and not mere survival or animal existence. Here, when we are not giving a choice to women and we are expecting them to be subjected to certain standards which have just been followed over the time immemorial, and we do not give them the choice to decide whether they want to exercise that right or not. It goes against the principle of Article 21. Not only that, in most of the cases where talaq-e-hasan is practiced or other forms of talaq which do not give women the right to choose, women are forced into destitution and poverty. Women and children are equally subjected to unfair circumstances, which is why we contend that Article 21, 14 and 15 are all violated. Your Lordships, with your permission, on the same grounds, I would like to touch upon the second issue that I have. Your Lordships, in the matters of inheritance and succession, as I discussed in the beginning of the proceedings, Nishi tribe, which is the tribe in question where the woman was denied her right to inherit her father's property along with her mother. Your Lordship, when we talk about inheritance, women are seen as inferior in these communities. That could be because of lack of education, but then the whole community is lacking on those fronts. Men are usually the breadwinners in these communities, and the properties, also the lands, are also agricultural lands that we're talking about. And women are expected to move to their marital homes after marriage, and hence they are not given that inheritance rights. But in many cases, we've seen that these women are forced into destitution. They do not have any property rights from the parents' side, and then from the matrimonial home, they are subjected to, in case if they are subjected to cruelty, they do not really have any resort to.
Before you could proceed, you're addressing the submissions on issue number 1 and issue number 3.
Issue number 3, Your Lords.
And you want this court to hold the law governing on these issues to be unconstitutional.
Yes, Your Lordships.
Which is those laws you are referring to specifically?
Your Lordships, we are dealing with personal laws, but only those personal laws which are discriminatory. Our submissions are talaq-e-hasan, ila, zihar, and other practices which are...
In the second one?
In the second one, Your Lordship, when we talk about inheritance laws, in Muslim community, for example, a male heir is given twice the property, twice the share in property when compared with a female heir. The daughter is given half the share.
Read your
Your Lordship?
prayer column of your petition. Prayer column of your petition.
Sure, Your Lordship.
Please read.
The first prayer.
Please read all the prayers.
Wherefore, in the light of issues raised, arguments advanced, and authorities cited, it is most humbly prayed before this Honorable Court that it may be pleased to declare that the impugned forms of divorce under customary law are violative of Article 14, 15, and 21 of the Constitution, and therefore unconstitutional. Declare that the UCC, Uniform Civil Code of Kedarkhanam, is violative of Article 14, 15, and 21 of the Constitution, and therefore unconstitutional. Declare that inheritance and succession laws under personal laws are violative of 14, 15, and 21 of the Constitution, and therefore unconstitutional. These are declare that partners in live-in relationship are entitled to mutual rights of inheritance in parity with spouses in legally recognized marriages under the Constitution and their respective personal laws. Your Lordship, we have given this honorable, we have left it to the honorable bench to decide.
Next prayer.
Alternatively, direct the central government to enact necessary amendments to personal laws to ensure they are consistent with the principles of gender equality.
Other prayer, you want this court to direct the legislature to frame the law.
Your Lordship,
Can this court do that?
Your Lordship, I would like to submit that please ignore the word direct. The intention behind this prayer was to only direct the government and not the legislature to bring about a law. There is separation of powers, and according to the principle of separation of powers, the Honorable Court is not in the right space to be directing the legislature to enact on laws. So that was a folly on our part, and we would like you to excuse that.
Yes.
Your Lordship, I would like to call upon my co-counsel.
Please.
Council
Thank
seeks
you.
permission to approach the dais.
Yes, please.
Much obliged, Lordship. If it may please this Honorable Court, I am the counsel on behalf of the petitioners, and I shall be dealing with the second and the fourth issue, Your Lordships. The second issue, Your Lordships, is whether the law passed by Kedar Khand is violative of Part 3 of the Constitution of Aranyaraj. Your Lordships, in the present case, recently the state of Kedar Khand has enacted a uniform civil code. It is our contention and it is our humble submission before this honorable bench that this act is violative of various facets of this act are violative of many constitutional rights. They are, in essence, they are violating the fundamental rights under Articles 14, 15. I beg your pardon, Your Lordships. Your Lordships, it is our contention that it violates certain fundamental rights, especially on the grounds of freedom of religion under Article 25, and also violates certain other fundamental rights such as the right to privacy under Article 21. I shall just begin by giving a short background on the idea of a uniform civil code. Your Lordships, it was discussed in the Constituent Assembly on November 23rd, 1948. There was a discussion on the draft Article 35, which eventually ended up becoming Article 44 of our Constitution. The discussion was centered around whether this article should be a fundamental right or not. This was the discussion, and it was proposed in such a way, and the discussion revolved around whether this should be a right to all citizens, that they have a right to a uniform civil code, or whether it should merely be a directive to the state that it must act in a fashion that it brings about a uniform civil code. While the article was being debated, many representatives placed the argument that it cannot be a fundamental right because it would infringe the right of religious communities that have been practicing their personal religious practices for many centuries and sometimes millennia in some cases. Therefore, the suggestion was made that it also include the proviso that it shall not apply to the personal law of religious communities. However, after this debate was concluded, it was decided that this should not be a fundamental right but only a directive principle. Your Lordships, in effect, what the Constitution tells us is that this is an ideal that the government, the state, must aspire to when it brings about a law. It does not anywhere place the burden on the state to absolutely have to bring such a uniform civil code. Your Lordships, also, if we study the wording of that article, it only tells us that
How to the purpose?
I beg your pardon, Your Lordship?
How to the purpose of Article 44 in that case?
Your Lordships, it has a purpose, definitely, Your Lordship.
The Constitution has a purpose to achieve.
Indeed, Your Lordship.
How to achieve the purpose?
Your Lordship, what the purpose of this Article 44, it must also be read in light with the other directive principles. They are all together putting a burden on the state to act in a manner that brings about the morality that the Constitution was drafted with. That those are outlined more succinctly in our preamble, that there shall be justice of all sorts of economic, political and social justice, and that there shall be an upholding of the very basic principles that are essential to life in our nation. Those are the fundamental rights. We have given the utmost power and respect to fundamental rights. They can in no cases be violated. They are not absolute, but to prevent a fundamental right from being accessed, then there is a heavy burden placed on the state to meet reasonable restrictions. Only in the case that you are meeting reasonable restrictions can the fundamental right not be given. Even the right to life can be taken away if it is under the due procedure of law. Our contentions largely, your lordships, are that whatever the state has done, they have taken away fundamental rights without proving that it is a reasonable restriction. Under Article 25, your lordship, religious communities have the right to continue their practices. If a practice infringes on any of those any of the restrictions they are subject to, which is public order, morality, which is again constitutional morality and not the morality of some person, and health, which is again public health. So if it is breaking any of these barriers or any of the rights enshrined under any of the other rights enshrined under Part 3, this is a very high bar, your lordship. If this bar, specify on the grounds of?
On the grounds of why it is not violative, why it is not against public order.
Your lordship, it is to be, in the instant case, what we are saying is that the religious, the practices of any religious community.
You are referring to the law which is already passed with the State Assembly of Kedarkand State.
Indeed, your lordship.
Which is the provision according to you, while it's the, under what ground can we seek striking down a legislation?
Your lordship, major grounds, the major provisions of this law that we are challenging is one that mandates that every marriage must be registered. Your lordships, in the present condition, apart from in the ambit of personal laws currently that are applicable to Hindus, for example, there is no compulsion for a Hindu person to register his marriage. A Hindu marriage will be given the same weightage as a registered marriage, even if it is not registered, if the ceremonies have been performed. If the parties have participated in that ceremony willingly and have done their bit in their, if they have submitted themselves to the ceremony and have performed it, then their marriage is taken as valid. There is no compulsion that a marriage has to be registered. The only religious denomination that in our nation that has a process of some form in which a marriage will be eventually registered is the Muslim community, because they have a nikah nama. It is a contract, not just a sacrament as in other religions, although even under Muslim law it is also considered not just a contract but also carries the force of law from the Quran. But other forms of other religious communities do not have the burden of having to register their relationships.
Since on registration of a marriage, how does it violate a fundamental right? Which is the fundamental right violated under that?
Your lordships, if I do not register my marriage, then my marriage will not be considered valid. Many the Honorable Supreme Court has already stated in a few cases that there is no reason to doubt the existence of a marriage if the registration is not done. So, in effect, there are marriages that have not been registered.
For instance, which you are opposing this law?
Your lordships, on the grounds of privacy, when we come to the section on live-in relationships, your lordships, there is firstly a compulsion, there is an obligation. The word uses the partners in a live-in relationships are obliged to register their live-in relationships. They have to apply to the registrar, indicating that they are entering into a live-in relationship, wherein the registrar will then conduct a study and, if needed, call upon the parties and ask them if to satisfy himself whether they are actually in a live-in relationship, and then issue a certificate which registers them as a live-in couple. Your lordships, it is our humble submission that forcing every person who decides or desires to enter into a live-in relationship to appear before the state to prove that they are in a live-in relationship and to declare and to have it as a matter of public record that they are in a relationship currently is violative of their fundamental right to privacy. As held in the landmark case of Justice Puttaswamy, we are forcing, it said that we cannot force anyone to reveal what they do not want to reveal. If they want to keep something private, if it is a reasonable personal fact that they want to keep private, then it should be allowed to them. We should be...
Privacy versus personal rights. If it's pitted against each other, which one should be preferred?
Your Your Lordship, I would request that in the case of personal law,
If a couple, take hypothetically, couple have decided to have a living relationship. They don't disclose outside the world what they are. For whatever reason, if there is something goes wrong and she is subjected to harassment, her rights, individual rights are taken away. Under what circumstances can she seek redressal of her rights?
Your Lordship, she can seek remedy under the law for domestic violence, protection of women from domestic violence.
If law asks you that yes, if you want to say that you have acquired certain rights being in living relationship, please tell us that you are living with this person. What's wrong with this?
Your Lordship, it is our contention that there is no option given to people to enter into a relationship.
Isn't it to maintain the public order, to maintain the constitutional morality, to uphold the dignity of a woman that this provision is brought in?
Indeed, Your Lordship, I agree that the intention behind bringing such a law...
Yes, please.
If you agree, you have lost the case.
No, I am not agreeing on the validity. I only agreed, Your Lordships, that the intention behind the legislation might have been fair. However, the implementation and the way it has been drafted, it forces couples to...
Accordingly, what is privacy?
Your Lordships, if there are certain aspects of my personal life and my body that I choose not to reveal or to have to submit before the state, I should not, those must be allowed for me to be kept private.
Registration before an authority, are you going to reveal your body?
I am revealing my... no, indeed not, Your Lordship. I am not saying that in this case they are asking me to reveal the body, but they are asking me to reveal my personal details. They are asking me to reveal who I am living with. They are asking me to reveal where I live. And they are also asking me to seek my parents' consent if I am under the age of 21.
Okay. Is that not for the safety of the public order?
Indeed, Your Lordship, but public order could still be affected even after the UC or even after these rules regarding living relation.
On the fourth issue also, right?
Not Your Lordships, on the second issue. Yes, Your Lordship.
The argument is contradictory.
Your Lordship, on the second issue, we are representing certain religious communities in the state of Kedarkhand because the state of Kedarkhand has enacted this particular uniform civil code. Whereas in the fourth issue, we are representing the NGO who is the original petitioner in this case, which applies to the other the rest of the Union or the Republic of Aranya Raj, where there is no such uniform civil code, and these particular provisions do not apply on any other part of the nation apart from the state of Kedarkhand.
Counsel, I have a question for you.
Please, Your Lordship.
If you register a living relationship, would it not be possible to defeat the Indian Penal Code as it was in the old days and now as amended on the question of bigamy? Now, here is a man who enters into a living relationship with a lady, is not registered. Tomorrow he gets into a relationship with another woman and is not registered. This could keep on happening, and technically he would be living a bigamous life. So would it not be provident to ensure that this kind of immorality doesn't survive in the country by insisting on a registration here? Would that not be a proper thing to do?
It would, Your Lordship. However, in the present situation, there is a law against bigamy. However, people are still managing to get around that law. The law says...
That is exactly what it is. You are not supposed to do this. It's an offense under the IPC or the BNS today. So in view of that, isn't it not a proper thing to have registration of a human relationship to be affected? And why should you glouse about it?
Your Lordship, the ground...
The right to privacy being affected here. When a man is doing something so blatantly with any number of wives, that's what happened in the old days, with any number of wives, and that's why the law against certificate came into existence.
Indeed. Your Lordship, in other parts where such a code does not apply, a Hindu man who is already married, if he does not perform the ceremonies and chooses just to live without performing the ceremonies, he can still in effect lead a bigamous life, and there is...
That's a question if there is void or voidable.
Indeed.
But registration would be really helpful, and it would protect the woman dignity some degree of strength in that relationship.
Indeed, Your Lordship. However, this is coming at the cost of me revealing my identity, revealing who I am living with and my address. I might be living with...
But you would have to do that if you are entering into a marriage.
Under special.
Who you are married to.
Indeed, Your Lordship.
You require that information.
Indeed.
Paternity, children, passports, all these issues arise, and you require this kind of information to be placed before the authorities.
Indeed.
Why are you hesitant to place it before the government and say, issue this on these lines?
Indeed, Your Lordship, our country has always had this intention of, that is why the Special Marriage Act was brought in. If people from different communities wanted to marry, the personal laws would not allow it, and so we had a Special Marriage Act that allowed such relationships. Your Lordship, in the present state in our country, although it's the 21st century now, we still have cases of honor killings. When families find out that their child is marrying or is living with someone of a different community, there have been cases where people have hunted such couples down far away from their home. Even if they have tried to lead their life in some other part of the country, they have been tracked down and butchered. They have, in effect, while saying that...
I think you are answering my question there. The question that I am posing to you is registration a proper act or an improper act?
The act of registration would be proper, Your Lordship, but the fact is that it is coming at the cost of me having to reveal details that could put my life in jeopardy.
The police can always inquire into it if you are in a bigamous relationship.
Indeed, but that could also be done in the present state, Your Lordship. Outside,
you are born in that kind of a relationship. In the school, when you have to admit him, you want to know who the father is, who the mother is, if scholarships are to be given, if caste factors are to be considered.
Your Lordship, it cannot be that the burden is placed on the person to have to register under the pain of a fine and jail. Because if under the present law, if the person fails to register such a live-in relationship, the punishment could be 6 months in jail or a fine of 25,000. That, in our opinion, is unfair. It places such a heavy...
Your submission is that it affects your right to privacy.
Indeed.
Therefore, the provision providing compulsory registration is violative of fundamental rights.
Yes.
Go to fourth.
Fourth issue, Your Lordship. Your Lordship, also on the grounds that it affects my fundamental right to life and my freedom to live my life, my personal liberty, because then I could also end up in jail, so we did not touch upon that. But Your Lordship, moving to the fourth issue.
Whether partners in a living relationship are entitled to mutual rights of inheritance.
Indeed, Your Lordship.
Spouses in any form of marriage under the Constitution and their respective personal laws.
Indeed,
we should move forward.
Indeed, Your Lordship. Your Lordship, in this case, it is our contention that partners in a live-in marriage, in a live-in relationship are entitled to certain rights, and in the present framework, they are not being provided those rights. Your Lordships, we place reliance on the case of D. Veluswamy, in which the Honorable Supreme Court noted that there are 4 guidelines, or there are 4, they lay down 4 thresholds, that if a person meets, or if a couple meets these 4 thresholds, then it will be deemed that they have entered into a common law marriage. So when the question of the presumption of a marriage was placed before this court, the Honorable Supreme Court came up with this, with these rules, that firstly, if you are in a relationship in which you are to the world at large, you are presenting yourself akin to a married couple. Second, that you are of legal age to marry. Third, that you are not already married. And fourth, that you have voluntarily cohabited for a long period of time. If you are meeting these 4, then you will be deemed to be married to that person. It is a presumptive marriage. Your Lordships, in the case of children of these...
What's the degree of relationship to the person you are living with? If you are in the prohibited relationship, you can't enter into that living relationship.
Indeed, it was not held in this particular case, Your Lordship, but then yes, there are bars on certain relationships that you can, those would be on the grounds of just morality in the sense, and also health, because children of people related through blood might have genetic disorders.
It could make a difference in discussing in deciding that particular issue.
Indeed, Your Lordship, Your Lordship, in this case, we are talking about the Republic of Aranya Raj. These people do not have any such provision here. Such a provision would protect these communities, but it is only enacted in the state of Uttarakhand and not available to the rest of the Union. And in the rest of the Union, what is the situation is that the court recognizes that if you meet a certain bar, then you are deemed to be in a presumptive marriage and you have certain rights. However, there is no law that protects these living couples. What happens in a case where one of them dies and they have not actually entered into any bigamous other relationship, whether marriage or whether a second living relationship, and they should have been protected because they have met these four conditions, and still they do not get any right automatically because there is no such statutory provision. Each such couple will have to come and petition the doors of the court, and to win their rights eventually might take them decades or sometimes even longer, because the legal process is long drawn out and it might take too much effort. They might not be able to do that. Your Lordship, I seek for a small extension. Your Lordship.
Issue here basically is exercise of powers under the concurrent list.
Indeed, Your Lordship. Indeed.
Now, if you were to remove these provisions relating to marriage, transfer of property and things from the concurrent list and place them in the central list, you would have one uniform civil code for the whole country.
Indeed, Your Lordship.
Because you could run into difficulties with this state having their particular predications and another state having other predication.
Indeed, Your Lordship.
Wouldn't that be the simplest thing to do? To remove these, amend the Constitution in terms of Article 368, remove Articles items 5, 6 and 7 from the concurrent list to the state central list?
Your Lordship, that would require an amendment of the Constitution, and that would also...
That would solve the problem to the whole of India.
But that would be taken...
You have the body deciding the issue for everybody on, and you have the legislature there, with the parliament there, which is stacked with the powers of the people of the whole country.
Indeed, Your Lordship. However, it would take away the rights that are currently given to states to govern themselves or to make law in those matters. How can we...
If you are looking for equality and equal protection of law, that should be the issue involved, no?
Indeed. However, Your Lordship...
Equality for the whole nation and equal protection for the whole nation.
Indeed, Your Lordship. However, such an amendment would only be possible if the states consented to it. If the Council of States, which is made in our federal structure, is designed in such a way, Your Lordship, that the states have been given these rights, that under these matters you are also competent to enact legislation. Taking that right away through a constitutional amendment to the 7th schedule would require the consent of the states themselves, unless the Council of States also...
But they also have fundamental duties, 51A.
Indeed, Your Lordship. Indeed, Your Lordship.
Which also predicates certain duties.
Indeed, Your Lordship.
Taken from the Russian Constitution.
Indeed, Your Lordship.
Enshrined in Article 29 of the Universal Declaration of Human Rights. If you see Article 51AE, please see what it says. Then you have to discern between a fundamental right and a fundamental duty. To promote harmony and the spirit of common brotherhood amongst all the people of India, transcending religious, linguistic and regional or sectional diversities, to renounce practices derogatory to the dignity of women.
Indeed, Your Lordship. Your Lordship, it is our humble submission that we must look at all of these in a harmonious way. Your Lordship, the fundamental duties, also the directive principles of state policy, which tell us that if we look at it in a whole, we are obligating the state to move in that direction of creating such a state where all these rights are protected. The state...
Directive principle of state policy on the fundamental duties are justiciable?
Your Lordships, they are not justiciable before a court of law. They are merely directives to the state to in what manner they should act, what should be the goal when they are enacting a legislation. That is what the directive principles tell us, and Your Lordships, the fundamental duties tell us what should be the thought behind our actions when we act as citizens in our country. In order to promote what the vision of the Constitution, both these parts of the Constitution were included, the fundamental rights and the DPSP.
What are the issues? Section 58 of the Indian Evidence Act, have you seen it? What is enforceable in Section 58 of the Indian Evidence Act? Customary laws can be enforced.
Your Lordship, indeed, Your Lordship, and our submission on the first and the third issues where we're talking about customary law and personal law is not against the law in toto. Your Lordship, we are well aware that it is a privilege that we have. We are the largest democracy in the world. We have possibly the largest number of languages, the largest number of different communities. We have a great culture, and we are not here seeking the prayers before this honorable bench to declare, to remove all that. We also want the preservation of all of these in view of the morality of our Constitution. We only are here, Your Lordships, because some of these practices, some of these situations and cases are such that there is a violation of certain fundamental rights. As we have shown in the case of divorce, there is an option to the husband to give a divorce without grounds or consent, whereas the wife is not given the option of exercising a divorce without rights or consent. In the case of customary law, in the case of law related to inheritance, there are certain situations where a woman is given half the share or even less, or sometimes not given anything at all. Your Lordship, we are only challenging that certain aspects of these laws are unconstitutional. Our prayers are to the effect that such portions of either the personal law or either customary law or any enacted law as well do not pass the test of fundamental rights, and they cannot be allowed to be implemented in our country, Your Lordships. It is of prime importance that the Honorable Court, the highest court in the land, declare and adjudicate these matters so that such injustice is not perpetuated for long times to come.
You are going on the basis of the issue here on in the case of Raj and Rachel.
Indeed, Your Lordship.
That's what you're talking, but technically I don't think you have a grievance there at all. If you take the facts of the case here, this property was acquired by men in a living relationship. Both the man and the woman have purchased it. So 50% of that property was already hers.
Indeed, Your Lordship.
There was no question of the relations claiming a right in that.
Indeed, Your Lordship.
This child is born of that relationship.
Indeed, Your Lordship.
Relationship is also an issue that is granted here.
Indeed, Your
The child will automatically inherit this property.
Indeed, Your Lordship.
From the father.
Indeed, Your Lordship.
Because the absence of a mother there, because he was a Hindu, and in class 1S, the mother also is reckoned there, but this is not indicated here. So you have no grievance here.
Your Lordship.
The child would get 50% of that property, and the wife already owns 50 of it.
Your Lordship, we are not contesting at all that the rights.
This is going to be the basis for your grievance constitutionally or as a fundamental duty that will not
Your Lordship,
substantiate your case there.
No, Your Lordship, what is happening here is we are not contesting that the illegitimate, our constitution and judgments have also held that we do not, the concept of bastardry is to not be.
Last question.
Your Lordship.
One last question.
Your Lordship.
You have joined several causes of action in this petition.
Yes, Your
What
Lordship.
does this mean?
Your Lordship, this is originally a writ petition under Article 32. It is a public interest litigation. Your Lordship, the petitioners are Khawatine Samanadhikar, which is an NGO, and certain religious organizations, which was the original case in the High Court of Kerala under Article 226, which was also included under as one of these issues. Your Lordships, the petitioners are representing a large section of society. In the case of the first issue, all the Muslim women. In the case of the third issue, all the women in our nation who are not given equal succession rights. In the case of Kerala, of course, the religious organizations and the people of Kerala. And in the fourth case, Your Lordship, people who are in that situation where they are not in a legal marriage and are not getting the right that should accompany to them. Because this is a public interest litigation, Your Lordships, our humble submission is that if it meets the guidelines set in SP Gupta, in the landmark case of SP Gupta, where the Honorable Court already laid down the guidelines of what would meet the bar of a public interest litigation. If those requirements and guidelines are met, then such a writ petition is definitely maintainable, Your Lordship.
I don't think you're answering His Lordship's question. He said you joined a whole lot of causes of action in one petition over here. But technically, if you see, your own Moot tells you that all these petitions which are pending on various other causes of action in various courts in the country have been
clubbed together by
that should be your answer to the issue.
Yes, Your Lordship. The petitions are separate and maintainable in all the under the jurisdiction. Indeed, Your Lordship. The Honourable Court has included all these under the power under Article 139A. Your Lordship, on the issue of the...
This is an analogous hearing of all the other petitions.
Yes, indeed, Your Lordship. Your Lordship, just one more submission on the point Your Lordship raised about the child. Of course, the child is getting the rights. We are not contesting that at all, Your Lordship. The only contestation is that whether the partner is given the right. In the instant case, Your Lordship, indeed, though the lady has put in 50% of the property, there is also the provision that the husband could have written a will and the testamentary disposition would have gone as a Hindu male. He could have given testamentary disposition to his living partner. Unfortunately, in this situation, perhaps we are not given the complete fact, but the fact is that the family of the man has taken the house, and the woman is not left with any recourse.
Say the family has taken the house. They only say they are opposing it.
Your Lordship, I would request a minute to consider the facts again. I think... Your Lordship, the parents are contesting and taking over the property, leaving the woman to herself.
They don't say they've taken over. It's just saying that they are considering it.
Your Lordship, but
in the favor of the child.
Indeed, Your Lordship.
It will only be that because the wife is half owner.
Your Lordship, that unfortunately is not established clearly.
It's mentioned in the issue itself. Subsequently to the same, they purchased an apartment by contributing equally to the expenses and procure the same. Section 45 of the TP Act will tell you that when it comes from a common fund, it's equally owned. Section 45 of the Transfer of Property Act. Please check that in.
Your Lordships, our contention is that if such a relationship would have been given mutual right of inheritance...
Irrespective of that relationship, there are two people here who own this property. It relates to joint owners, and the TP Act very clearly says if you cannot establish it in going to that extent, that as to who has contributed that money, they own it in equal shares.
Your Lordship, in the present case, perhaps yes, this would save the lady.
The present case which you have cited is the basis for your writ.
Your Lordship, but Your Lordship, this is a
cause of action for you then.
Indeed, Your Lordship, but this is one particular case. We are bringing a constitutional question.
Not indicated.
Your Lordship, what if the woman had not contributed? In such a situation, then she might have been left destitute.
You can't play with imaginary situations there. You have to deal with the case as you place it before the court.
Indeed, Your Lordship. However, it is a humble submission, Your Lordship, that this is one individual case. We are not asking Your Lordships to be deciding the matter.
The individual case that you are citing doesn't help you in your argument there. It doesn't support what you are trying to advance.
Indeed, Your Lordship, but we are not placing reliance only on this particular instant case, Your Lordship. What if in the case of women who are in such relationships but did not have the financial capacity to contribute to 50% of the marital properties, of the property...
Basically, you are exposing the cause of those who do not fit into your fact with regard to issue before.
Your Lordship, we have been given this fact. This is the one issue we have been given. But in a constitutional question, we are not only asking on the behalf of this one party. We are saying that this situation needs to be addressed, Your Lordship. If people are entering into such relationship, it is quite possible a woman might not have the agency or the financial capacity. But those situations are what we are praying before this Honorable Court for defense. Your Lordships, with that, I have submitted all the contentions of the petitioners. Your Lordship, Council seeks permission to recite the prayer. Your Lordship, I would request and plead with Your Lordships that we do not consider the last two alternative prayers. They were erroneous, and that in the first alternative prayer we are said to enact necessary amendments, but we would...
asking for deletion of those prayers.
The last two prayers, Your Lordship, and the one... Your Lordship, wherefore in the light of issues raised, arguments advanced and authorities cited, it is most humbly prayed before this Honorable Court that it may be pleased to declare the impugned forms of divorce and the customary law as violative of fundamental rights and therefore unconstitutional, declare that the Uniform Civil Code of Kedarkhand violates fundamental rights and is therefore unconstitutional, and declare that the impugned inheritance and succession laws under personal law are violative of fundamental rights and therefore unconstitutional, and declare that partners in live-in relationships are entitled to mutual rights of inheritance. Alternatively, we pray that the Honorable Court direct the central government to inquire into the possibility of amendments to personal laws to ensure that they are consistent with the principles, or alternatively direct the Law Commission to study the impact of existing divorce, inheritance and succession laws on women's rights and recommend uniform amendments to eliminate such discrimination.
Why are you asking for the central?
Your Lordship,
Ask the central government to do this.
No, Your Lordship, we are asking the central government to inquire into the possibility of creating that in light of achieving what is the goal of Article 44.
You're asking them to invoke Article 44.
Indeed, Your Lordship. Or pass any other orders or orders that this Honorable Court may deem fit in the interest of justice, equity and good conscience. For this act of kindness, the counsel for the petitioner shall duty-bound forever pray. Much obliged for the opportunity of hearing, Your Lordships.
Your Lordships, before I get into my contentions, I would like to give you a little approach, a little clarification into our approach. So here, there were 3 writ petitions filed in different high courts by 3 different women, and then there was a Uniform Civil Code implemented in the state of Kedarkhand, and there were many religious communities who have filed a writ petition against the implementation of UCC in the High Court of Kedarkhand. And furthermore, NGOs, Kwatina Samandikar, filed a writ petition under Article 32 in Supreme Court. Subsequent to that, Supreme Court has invoked Article 139A and transferred all the cases regarding this matter pending in every High Court of the territory. And it has transferred all the cases clubbed with the petition of NGO. So now here I am Speaker 1 and I will be representing the union defending the contentions put forth by the NGO that customary laws are violated, and the Speaker 2 is representing the state of Kedarkhand, who will be defending for their Uniform Civil Code. Your Lordship, in the state of in Aranya Raj, in the Union of Aranya Raj, we follow a legal plural system. So here we have different personal laws for different religions. That is pursuant to Article 25, which is guaranteed in the Constitution. Your Lordship, so here we have different personal laws for different religions. So we have different divorce provisions in different religions. In Hindu Marriage Act, we have Section 13, 13A, 13B. All of these grounds are for the judicial form of divorces, and they are not against the Constitution. They are equally there for both man and woman. Now coming to the Indian Divorce Act, which is an act for Christians, where we have a gender-neutral procedure for divorce provisions as well, so that the laws for Christians is not going against the Constitution as well. Now coming to Muslim law, here under Muslim law, which derives its source from the Quran, has given 4 to 5 forms of divorces for Muslims. So here, the question here raised is talaq hasan, and they call it arbitrary and not equal. Your Lordship, that is not the case. We have different provisions under Quran, one talaq hasan for a man and khula for a woman, and talaq tawfis as well for a woman. So here there are 2 different provisions, not unequal. One is for a man and one is for a woman. So Your Lordship, the talaq, there is nothing arbitrary here and there is nothing unequal here. Your Lordship, also coming to the point of arbitrariness, in talaq hasan there is enough time, 90 days of time for reconciliation. It is not instant. That is the whole reason why we brought amendment and why we brought Triple Talaq Act and removed talaq biddat, because that was instant and that was going against the women's dignity. We do care about our women. So here talaq hasan is not instant. instant. It is not also going against Article 14. And khula is a provision given for a woman where she can take divorce, Your Lordship. Also, under Dissolution of Marriage Act, we have Section 2 where certain grounds are given for a woman to even take judicial form of divorce. So here she has a way of extrajudicial divorce and also a judicial divorce. Nothing is going against her dignity, neither her fundamental rights are being violated. Yes, Your Lordship.
Raising the apprehension rather, is that there is no checks in exercise of this right given in the scripture by the husband while he pronouncing talaq-e-hasan or talaq-e-hasan, though they are held to be valid. So how do you ensure that? If there is arbitrariness, no opportunity is given,
Your Lordship,
how do you point out that aspect? How do you defend that?
Your Lordship, the 90 days of the period is enough time.
Basically, that relates to the menstrual period.
Yeah.
It's talaq or 3 tours.
Yes, 3 to 1.
It's more for the menstrual because even after a divorce, you have to
Observe with that period, yes. Your Lordship, it is 90 days of Tuhur period observed. So here during...
menstrual cycles.
Yes, 3 menstrual cycles. So that period, 90 days period is enough for any checks into that practice and also enough time for reconciliation. And
is there a provision under your scripture regarding any mediation, arbitration to be conducted before initiation of this process?
Your Lordship, the chapter 296 of Quran does mention that there should be an effective reconciliation. How? Yes, definitely. It's not given how, but there should be an effective reconciliation that is definitely there. But the ground...
Participating in the reconciliation process?
It can be the family and the couple itself, or just the couple.
Is there any period prescribed fixed for that purpose?
Prescribed?
For conciliation process?
No, Your Lordship. There is no prescribed conciliation. Yes, Your Lordship.
What's your answer for the...
Your Lordship, because the procedure is not prescribed, but coming to the ground reality, in the ground reality, the families and the parties, both of them get enough time to reconciliate. The procedure here may not be prescribed in the Quran itself, but in the ground reality, this is what happens where the families and both the parties equally get to sit and reconciliate between them.
I have a question for you.
Yes, Your Lordship.
There is what is known as the Muslim Women Protection of Rights on Marriage Act of 2019.
Yes, Your Lordship.
Where these talaqs have been rendered void ab initio and also cognizable and could be penalized also for it.
Yes, Your
Now,
Lordship.
by doing this, you have removed technically the right of a man to seek dissolution of marriage in this form. There is no other provision anywhere in the Muslim law which enables him to go to the court. Other than in personal law itself, on the sort of a joint petition basis, which is now being observed by the courts. So the question here is any woman really offended by this?
Your Lordship,
Or discriminating against a man here? Do they have a right of action in this? My question to you.
Your Lordship, when it comes to a man, he has 2 to 3 forms of talaq. First, talaq-e-hasan, talaq-e-hasan, and also talaq-e-tawfiz. He has already been given 3 forms in the Quran itself, and the Muslim men follow that provision. So he is not remediless either. So here there is equality between both man and woman when it comes to divorce provisions, Your Lordship. And also, Your Lordship, under...
No, I beg to differ with you. The definition of talaq refers to all the, instead I'll read it out to you. Talaq means talaq-i-bid'ah or any other similar form of talaq having the effect of instantaneous and irrevocable divorce pronounced by a Muslim husband. So your contention is wrong.
Your Lordship, my contention here is talaq-e-hasan is neither instant, neither...
The definition is all encompassing.
Your Lordship, the definition is regarding talaq-e-bid'ah.
The Second High Court has clearly held that the Muslims don't have a right to seek divorce in the courts.
Your Lordship,
Formerly it was done in Muhammadan law by filing a civil suit in the courts. But today that is withdrawn.
Your Lordship, that case and that act is particular about talaq-e-bid'ah, which was a triple talaq form which was instant and not revocable. So that act is only pursuant to triple talaq. Talaq-e-Hasan and Talaq-e-Hasan is still available for a man to invoke the divorce. Your Lordship, now coming to Hindu Marriage Act, where Section 29 Clause 2 gives powers to any customary dissolution of dissolution of marriage. Your Lordship, even there, the couple has to come and validate their customary divorce deed through which they take a divorce. Even that should be validated in the court itself, where certain checks can happen. So here, any form of divorce implemented by the union or in the customary laws, none of them are violative of any fundamental rights, neither are they going against the Constitution.
Is there a distinction between a customary law and a personal law?
Your Lordship, here in this context, they should be viewed with the similarity, because the personal laws are ultimately taken from the customs itself. Your Lordship,
What happens to Article 13, Sub-Rule 3?
Your Lordship, Article 13 Sub-Rule 3 says that law includes customs and usage. Yes, when a custom is reasonable and not going against the Constitution, then yes, even that forms as a law. Your Lordship, now moving to my other contention, that is about inheritance. So here the question raised for inheritance, before that I would like to clear that that already implemented inheritance laws are all equal under Hindu Succession Act. Here the man and the woman get equal rights in property. Under even Indian Succession Act, they get equal rights to the property. The question here raised is about tribals. Your Lordship, the tribals here are given special protection under Article 244 and 244A, pursuant to which we have Schedule 5th and Schedule 6th. Schedule 6th makes two councils. One is district council and one is regional council. And the Constitution itself has given both those councils to make laws depend on the marriage, on the divorce, and also inheritance. So here the Constitution itself is giving power to the district council and regional council to make laws regarding the tribals in the state of Assam, Mizoram, Meghalaya, and Tripura. That is the Schedule 5th. Schedule 6th is only pursuant to those four states. Now coming to Schedule 5th, here the Schedule 5th on the other hand is applicable to all the other states other than the four states, and that gives power to the governor, and it also establishes a tribal advisory council which will be represented by the tribals, and it will be advising governor time to time basis, Your Lordship. And also we have, even there the tribals are not remediless, they are not lawless, even there they are being protected. Your Lordship, even under Indian Succession Act, the Section 2 says that the tribals will be included under this act unless the state has given a notification to the union that that ISA will not be applicable to this certain state. So here even ISA is applicable to tribals unless a state gives a notification. So there are even we have plenty of state laws, schemes, and even National Commission for Tribals, which is looking upon the tribals and which is always protecting tribals, and they are given special protection under Constitution, which is being totally followed and implemented, Your Lordship. Now coming to my third contention, which is about live-in relationship. Your Lordship, here the contention is that the parties in live-in relationship are in parity with marriage, hence that's why the inheritance rights should be given. Your Lordship, my point here is that they are ultimately trying to abolish the institution of marriage by telling that uphold live-in relationship in equality with marriage. Whatever cases we have right now adjudicated by the high courts or the Supreme Courts are in regardless with giving them protection or maintenance. So maintenance because the woman is aggrieved, protection because she has faced certain domestic violence or whatever. In pursuant to those two topics, they have been interpreted in such a way. Here the benefit of inheritance cannot be given to every live-in relationship whoever comes forward. So here the couple in live-in relationship, they neither have constitutional rights nor do they have statutory rights, Your Lordship. With this, I would like...
What is the definition of marriage?
Your Lordship, the definition of marriage is given under Hindu Marriage Act.
That is for the people who follow Hinduism.
Your Lordship?
If a person doesn't believe
Your Lordship, if the person does not believe in any faith, he will be governed under Section 21 of Indian Succession Act.
No.
I apologize. That is with two couples from different religions. If they register their marriage under Special Marriage Act, they will be governed under Section 21. I apologize. Your Lordship, here, however, the people who do not believe in any faith should be governed under and interpreted under Indian Succession Act, because
Even if a marriage is performed
yes, Your Lord.
by Muslims, two Muslims,
Yes, Your Lord.
and they register under the Special Marriages Act post that,
Yes.
then that marriage is deemed to be a marriage conducted or registered under the Special Marriage Act, and the parties are governed by the Indian
Succession Act.
there. Irrespective of what their religion, whether they're Hindu or Muslim, this is what happens.
Yes, Your Lordship.
Other than if it's the two of the same community.
Yes, Your Lordship. So here, that is my point being that we have enough equal laws that and that the Special Marriage Act, if there is any interfaith couple, the Special Marriage Act caters to that. And if coming to the question Your Lordship's raised, that if there is any other person who does not believe in any faith, they should be governed and interpreted under Indian Succession Act. So because the laws and provisions for inheritance under Indian Succession Act are equal.
Definition of marriage.
Your Lordship, the definition of marriage, I'm unaware about the definition of marriage given, but I can definitely give you a general meaning of marriage. So marriage is an institution where the couple is an institution of society where the couple hold themselves as spouses to the society, and they plan and they have mutual rights and property and many other
It
rights.
is defined as a relationship entered into by a man with a woman for the procreation of children.
Yes, Your Lordship.
So how it is different from a relationship, living relationship?
Your Lordship, here, for the marriage to be validated, if
Able person capable of deciding their own civil rights,
yes,
consciously come to an understanding that we stay together no matter how long, we procreate our children. How different that is from the definition of marriage?
Your Lordship, here I'll answer that question in two folds. First, we are not against any live-in relationship.
Special feature which distinguishes marriage from the living relationship such that only marriage, so-called marriage, couple under marriage are entitled for inheritance, couple under living relationship are not entitled. How do you distinguish that?
Your Lordship, if the couple is Hindu, then they should fulfill the conditions given for marriage under Hindu Marriage Act.
Fair enough, we got that.
Yes.
People in faith will follow their faith.
Yes.
People do not follow any faith, they do the follow.
Your Lord,
The so-called definition of marriage belonging to believers, marriage not belonging to believers, they want to title themselves living relationship. What's wrong with that?
Your Lordship, here the council or the union is not against the association of two people in a living relationship. That has been upheld, that is their right. We are not...
It's the law which prohibits right of inheritance between the couple who are having arrangement of living relationship.
Your Lordship, it does not specifically say. The Hindu Succession Act talks about spouses. It uses the word spouses. Even Indian Succession Act uses the word wife. So, and even under Muslim law, there is no such provisions given to the live-in relationship. So here it is very specific to the couple only, the married couple only. And only to convey my point that the union is not against the association of two people into the live-in relationship. They have all the rights to do that. They also have protections under DV Act as well as
We are on the question of inheritance.
Your Lordship, the inheritance is given only to the spouses and not to the live-in relationship. Every live-in relationship tomorrow cannot come and ask for the inheritance rights, Your Lordship. It cannot be given to every live-in relationship. That is a right given only to a wife or a...
Basis.
Your Lordship.
What is the basis for denial of that right?
Your Lordship, the basis...
I believe in any religious faith. I still want to live in a living relationship.
You can live under live-in relationship.
What that prevents me from asking inheritance, right of inheritance as a wife?
Your Lordship, here inheritance, for the inheritance right, which is exclusively for a...
A special thing which gives a person who gets into so-called marital relationship right of inheritance.
Your Lordship, first thing being living relationship can be ended without any judicial or extrajudicial form. It is a walk-in, walk-out relationship. Any time the woman or the man can choose to walk in, that is the biggest difference. Second being, biggest difference, also Your Lordship, the wife here should not be compared with the woman in the living relationship. That if you compare, you are in a way abolishing the institution of marriage itself. You are telling, fine, do not marry.
A living relationship is one in the nature of a marriage.
Yes, it
means it has the color of a marriage.
2 points, Your Lordship. In the nature.
And therefore the idea of procreation comes into play.
Your Lordship, 2 points. First, it is in the nature of the marriage, not the marriage itself. Second point, it was in the nature of the marriage was interpreted in the D. Veluswamy so that the woman can get the benefit of DV Act, not for the benefit of inheritance or any other right, only for the DV Act, because women in that case was aggrieved, Your Lordship.
Yes. See, inheritance can stem from by operation of law or by testamentary predication. Isn't it? There are two situations here. So consanguinity doesn't really need to come into play in such a situation, or marriage also doesn't come into a factor there. You can leave your property to anybody you want.
Yes.
It is only if you have not made a will or made a testamentary disposition, then the title in that property would pass on by operation of law. Yes. Transmission by law.
Yes, exactly, Your Lordship. So here the man, if the man wants, he can definitely leave a will or gift it to the manner of gift. Here the woman is not completely barred. The man can write it in the will or even can gift it to the woman. So she's not completely barred from getting the property. We are not rebuting that, Your Lordship. Also, I would like to conclude that and by reading my prior.
Thank you, Benedict. Your time is up.
Just the prior. Your Lordship, I humbly pray before this court that the writ petition should be dismissed with an exemplary cost.
Why cost?
Your Lordship?
Why cost they have come with the reasonable?
Baseless contentions, Your Lordship.
Yes. What is the issue you're addressing?
Your Lordship, I'm the Advocate General for the state of Uttarakhand, Kedar Khand. The religious community has filed a petition and Supreme Court has invoked 139, and they are contending here that the law passed by Kedar Khand, which is UCC over here, is violative of Part 3 of Constitution being fundamental rights. Your Lordship, I humbly contend that the law passed by Kedar Khand is not violative of the fundamental rights, Your Lordship. Your Lordship, coming to my first submission speaks about Article 44. Your Lordship, Article 44 speaks...
This piece of legislation, read your repeal section.
Sorry?
Read the repeal section in the legislation which you have just promulgated.
Your Lordship, in the present proposition, UCC is not provided. The statute that we're talking about is not provided. I'm sorry? That is, the UCC that has been provided is with respect to
Section 390, page 563 of your compilation.
1 second. Your Lordship, the UCC... Yes, Your Lordship, but the UCC that we have provided here is that of Uttarakhand, and I am strictly speaking about Kedar Khand. That is my neighboring state's legislation. Yes, Your Lordship. A moment, Your Lordship.
This is a hypothetical process. 390.
I'm so sorry, but in our companion we don't have.
Page 560.
Just a moment, Your Lordship. Apologies.
You want some water?
No, it's okay.
Court officer, give us some water.
Your Lordship,
Let's start your perspective.
yes, please tell
You
me.
are representing a state.
Yes, state of Kedarkand.
Act, legislative competence of your state.
Yes,
You want this law to be defended within the four corners of the constitutional provisions. So our request, please read the section what you repealed.
Your Lordship, even though page 560 talks of procedure for registration of live-in relationship, Your Lordship. Is that what you want me to do? Repeal, okay. Section 390.
Yes.
Subject to the provisions of Section 2 of this code, any law, practice, customer usage in force in the state immediately before the commencement of this code relating to the matters covered by this code shall cease to have effect within the territory of the state insofar as they are inconsistent with the provisions contained in this code.
What's the effect of that?
Your Lordship, it's trying to say that UCC, when it is implemented, the current personal laws that were previously there.
Personal laws.
Your Lordship, with respect to inheritance, succession,
Whether all those laws which you are seeking to repeal
yes, Your Lordship.
are the state legislature or the central legislations.
They are central legislation.
Do you have a legislative competence to annul, repeal the central legislature?
Your Lordship, Article 44 in the Constitution is letting the state to...
Do that, but do you have a legislative competence to annul, repeal the central legislation? If so, under which article?
yes, Your Lordship, under Schedule 7 of the Constitution, Your Lordship. Give me a minute. Since it is also a concurrent list, Your Lordship, in the third list, entry 5, we can also implement...
You can implement, but if there is a conflict between the state and the central legislature, which one would prevail? And if so, where do you get the legislative competence to pass such a law?
Your Lordship, in the present instance, what is happening is the personal laws that were there previously, they were very much going against the fundamental
I
rights.
understand that. We are not onto the merits of the law. We are asking a simple question of your legislative competence to pass such a law.
Yes, Your Lordship, under Schedule 7 of the article, we can implement UCC.
Proceed.
Yes. Give me a minute. So, Article 44 states that the state shall endeavor to secure for the citizens a uniform civil code throughout the territory of India. Yes.
Get that right. Do you have the legislative competence?
Yes, we do. Yes.
For the nation?
Yes, we do, Your Lordship.
A state can pass a law?
Yes, because it concurrently also means that
Which state is referred under 44? Is it a regional state or a center? How do you read Article 44? The state reference is what?
the state can be both here, Your Lordship, because since
Read
it's...
Article 44.
Yes. The state shall endeavor to secure for the citizens a UCC throughout the territory of India. Yes, so even the union has the authority to implement UCC, but me being my state, me representing my state, I am implementing it, Your Lordship, because there were a lot...
Across the country.
No, Your Lordship, I am only implementing it in the state of Kedarkand.
In the regard of your power under 44, can you trace your power for this legislation?
I'm sorry, Your Lordship.
Can you trace your power for Article 44?
Yes, Your Lordship.
Yes, next.
Yes. So, Your Lordship, the state of Kedarkand has implemented UCC because there were a lot of inconsistencies with respect to the personal laws that were there. Your Lordship, constitutional makers also emphasized back in those days to implement UCC. One second, Your Lordship. ultimately, Your Lordship, UCC was implemented by the state to remove all the discriminatory personal laws that were there with respect to both men and women. What happens is that, Your Lordship, for example, let's take talaq. Talaq is a non-judicial form of divorce which was under Shariat Act. It was being given I'm so sorry.
Take your time, relax.
I'm just trying to point out the inconsistencies which were there in the personal laws, Your Lordship. With respect to divorce, the talaq that was present in the personal laws, Your Lordship, it was very unilateral and arbitrary in nature, Your Lordship. It was going very much against the section of women itself. And since we all... I'm really sorry.
So, take your time.
And even in the...
Right up.
I'm sorry?
Refer your right up. You have your memorandum. Refer to that.
Yes.
Go through that. Make your point what you want. Please refer.
Yes. Your Lordship, the state of Kedarkand as well as many other provinces and union territories have recognized the objective of our constitution makers to implement UCC because it ultimately streamlines the whole legal procedure. Your Lordship, what is happening here is that since there are many legislations, many interpretations are happening which is going to cause a lot of confusion and discrepancies. And by way of implementation of UCC, both men and women in terms of inheritance, succession and divorce will be governed on an equal footing. And this is going to ultimately streamline the whole legal process aspect of it, Your Lordship. This will also lead to an increased trust in the legal system and a sense of fairness and equity for all citizens, regardless of their religious or cultural background, Your Lordship. Ultimately, UCC can play a crucial role in promoting social cohesion, integration within a multicultural society, therefore fulfilling the ultimate objective of Article 44, Your Lordship. Coming to my second contentions, it is with respect to freedom of practice of religion. Religious communities are claiming that by way of implementation of UCC, right to freedom of practice of religion is being abrogated. Your Lordship, as per Article 25 in the Constitution, it says that freedom of conscience and free profession, practice and propagation of religion is subjected to public order, morality and health and to the other provisions of this part being the fundamental rights. All persons are equally entitled to freedom of conscience and the right freely to profess, practice and propagate religion. They are contending that by way of implementation of UCC, their right to freedom of practice of religion is being completely abrogated. But that is not the case, Your Lordship. I would like to tell why that we are not abrogating we are not violating Article 25. It is because Article 25 is subjected to public order, morality, health and fundamental rights. What is happening here is that the personal laws which were there previously, they were violating fundamental rights, Your Lordship. And it is not an absolute right at the end of the day. Your Lordship, UCC here is going to...
Well, you're striking the balance between the concept of secularism and your law.
Yes, Your Lordship.
Which according to the apprehension is threatening their religious freedom.
Yes. Your Lordship, secularism is a part of the preamble itself, but the true meaning of secularism lies in treating people equally, and in this instance everyone is going to be treated equally with respect to succession, inheritance, marriage and divorce. Your Lordship, we are not removing the essential customary practices such as saptapadi, nikah, Your Lordship. We are only trying to remove the discrepancies in the personal laws with respect to inheritance, divorce, and we are going to bring them on an equal footing at the end of the day, Your Lordship.
Why are you targeting only Muslim community in terms of getting UCC in implementation? Your argument started saying that it is to the Muslim community there is an inequality. Why are you targeting only one community to get UCC to be implemented?
Your Lordship, I humbly disagree that I am not targeting the Muslim community here at all, because there are also discrepancies with respect to, for example, in terms of inheritance, I will come to the tribal aspect of it. What is happening is 5th and 6th schedule is applicable to tribes, so that a tribal advisory council or an autonomous district council is being set up by way of...
That is inheritance.
Yes. I'm trying to say that there are discrepancies even for tribal women, because ultimately the right of inheritance for tribal women here, Your Lordship, is being governed under the customary laws. And if UCC is implemented, they will also come under the ambit of it, and even inheritance can be extended to them by way of a legislation rather than a customary practice that is happening, Your Lordship. Because certain customary, in certain tribes, certain...
The allegation is that it's a colorable exercise of your power. What was not expected to be done directly, you are trying to achieve indirectly. What's your answer?
No, Your Lordship, I am just trying to bring in uniformity with respect to personal laws for inheritance, succession and divorce. I'm not targeting any specific religion here, Your Lordship. I'm just trying to remove the inconsistencies which have been developed by way of the customary practices which were violative of the fundamental rights here, Your Lordship. Your Lordship, there are various other advantages of UCC. Firstly, it promotes national integration, Your Lordship. What is happening... Before I forget, I would also like to emphasize on Article 25, Clause 2. It says that nothing in this article shall affect the operation of any existing law or prevent the state from making any law. I am trying to emphasize on Clause B, which states that we can also provide for a social welfare and reform. Your Lordship, UCC here is a social reform that we're trying to introduce here, Your Lordship. That is what I'm trying to emphasize here. UCC at the end of the day is not abolishing any religion.
One is principle, and one is practice. Principle you have no difficulty because you also accept there is a source of law provided under the scripture, which is also recognized in the judgments of the apex court concerning the concept of secularism. That is, one can, and the courts have also extensively relied upon these scriptures.
Yes.
So that's in principle. The practice differs. Principle may something, practice is something else. Now, under the garb of addressing the practice, you are trying to take away the principle itself.
Your Lordship, I'm just trying to...
Okay. Justify this.
Your Lordship, I'm just trying to say that there are customary practices which are going against the fundamental rights, and that...
The practices, under the garb of those practices, like take talaq with the irregular talaq, it was both against the principle as well as the practice. In Sayer Banu case, last few pages of the 1,000 judgments, there's an affidavit filed by other contesting parties. They said yes. By definition itself, it is irregular, which is neither has a principle basis nor the practice. So therefore, legislation can step in, those practices can be removed.
Yes.
But now, there under judgment, Supreme Court has saved those two fundamental cases. By virtue of this UCC, you are trying to remove that principle also. Which is why we asked you, can you do that?
Your Lordship, we are not removing them, we are only regulating them, Your Lordship.
Principles or practice?
Both, Your Lordship.
Yes, proceed.
Your Lordship, coming to the advantages of UCC, it promotes simplification. There are way too many laws. When we already have CRPC, IPC, or right there, BNS and other, when they are regulating the human relation again, there is a unified civil code, irrespective of religion here or community here. Similarly, UCC is also, upholding the same values and telling that let's all be governed under the same laws. Your Lordship, the other thing is, it is, since it's a reform, it brings about modernization and development in the jurisprudence of family law itself. Your Lordship, it also, the major objective of UCC is to bring in gender equality in terms of all the personal laws here, Your Lordship. They will ultimately be treated on an equal footing. And in many judicial opinion by the apex court of Aranyaraj, they have emphasized on they have emphasized on Article 44, Your Lordship. In the case of Shah Bhanu, they have observed that Article 44 of a constitution has remained a dead letter. There is no evidence of any official activity. Your Lordship, this is also in our compendium.
Yes, it's correct.
Yes. They have emphasized and observed that Article 44 of a constitution has remained a dead letter. There is no evidence of any official activity for framing the common civil code for the country. Your Lordship, the state of Kedarkhand is ultimately trying to say that even when the apex court has opined and observed that...
Why have you chosen only these fields of law into civil code pertaining to only marriage, inheritance, custody. Why not other aspects?
Because-
Other aspects? Why not them? Only why this?
Your Lordship, the other aspects have already been codified. CRPC we have, CPC we have. They're already codified on a larger scale. But the personal laws were not completely codified. Every community had their own distinct personal laws, Your Lordship. And UCC, it can be an umbrella so that, everybody is under the same laws. Your Lordship, I would like to come to my prayer. I would like, therefore, in the light of the issues raised, arguments advanced, and the authority cited, it is most humbly prayed that this honorable court may be pleased to adjudge and declare that the law passed by the province of Kedakhand is not violative of the fundamental rights of the Constitution of Aranyaraj, and or pass any other relief in favor of the respondents. That is this honorable court may be pleased to grant in the interest of justice, equity, and good conscience. It is an honor presenting before you, Your Lordship.
Lordship's counsel seeks permission for a rebuttal.
Yes.
Much obliged, Your Lordship. Your Lordships, I shall split this into two because there were two different counsels for the matter. Your Lordships, on the first issue, we challenged this on the grounds that the woman does not have the option of a divorce without grounds or without consent. They defended these provisions on the grounds that the woman has the right of khula. As already submitted, Your Lordship, if the husband does not consent to a khula, will the khula initiated by the wife succeed? It does not. Your Lordships, on the ground of reconciliation, they said there is enough time. Is 90 days sufficient time for reconciliation? And in any case, Your Lordship, the divorce is initiated by the husband. There is also, they mentioned an invective that there should be reconciliation. If we read this as a compulsion or an obligation that every time a talaq is initiated there must be reconciliation, then there in effect will be no divorce at all. Also, Your Lordship, this is initiated at the mere whim of a husband right now. The Quran itself enjoins that every Muslim man must treat his wife with respect. He must not divorce a woman for no reason. He cannot treat a woman in such a manner that would be derogation of the principles of the Quran itself. However, Your Lordships, on the ground today, men are exercising this right for any whim or fancy. What, Your Lordships, prevents a man from initiating a divorce every year, once in a year, and then reconciling? What is left of a dignity of a woman who has to live under pretension, under the...
What is the basis for your exaggeration allegation? What are the statistics you have? What is the divorce rate?
Your Lordship, what I am suggesting is that it does not have to... there are, Your Lordship, what I am...
Every man is divorcing?
No, Your Lordship, what I am suggesting is that there is nothing... Your Lordship, even...
Many of them are divorcing.
Your Lordship, I request Your Lordship that...
Does it support the case?
Your Lordship, I only request that you consider the case where the divorce is not even finalized. I am not saying that divorce incidence amongst Muslims is extremely high. I am just saying that... in the
Threatened is what you mean. Being threatened.
Yes, the threat of a divorce for no reason always hangs perennially on the head of a Muslim woman. There is no protection against that, is what I am saying, Your Lordship. The reconciliation is only in the Quran that it says you must reconcile. But does every such...
What survey have you conducted before coming into the legislation?
Your Lordship, which... I beg your pardon, Your Lordship.
State, you are defending the act which has to bring this UCC for the purpose of...
No, Your Lordship, I am saying that certain forms of divorce, such as what they had mentioned, are still violating. Even the forms of talaq-e-hasan and ahsan, we have petitioned that they are not meeting the bar of fundamental rights. The respondents, your lordships, have relied on the case of Shaira Bano saying that talaqul biddat. But when you look at talaq Hassan and talaq-e-Hassan, in light of talaqul biddat, it is obviously more fair. But still, is it fair when we consider that there is no such option given to a woman? They have not addressed that. They have merely said that because there was a one form that was irrevocable and instantaneous, that was unfair. Our contention is there a ground that allows a woman also to initiate a divorce without grounds or without reason? Because men are practicing that indiscriminately currently. In many cases, the husband does not have any fair reason to divorce his wife, but can do so. That is what we are challenging, your lordships. They have, it is our humble submission that they have not been able to prove that the fundamental rights of women are not violated, that such threat does not exist on a Muslim woman throughout her marriage. They have not been able to effectively prove that, your lordships. Your lordships, on the second and on the third and fourth issue, your lordship, they said that tribals can consider that they are also eligible to be governed by the Hindu law. That would require them to give up their tribal culture. Why is there a requirement for them? Is it not unfair that we force the tribal communities to give up their customs and come and become Hinduized just so that they can get these rights? Are they not entitled to equality even though they are practicing their customary law? Your lordships, on the ground of live-in relationships, they said that we cannot grant recognition or mutual rights of inheritance to every relationship. Your lordship, we have never even petitioned on those grounds. We have not said that every live-in relationship should be given mutual rights of inheritance. We have already said that this honorable court has laid down guidelines and the bar is set quite high. You cannot be married, you have to be of legal age and you have to exhibit. In effect, we have discussed and the honorable court has laid down, I request just a few seconds here, Your Lordship, has laid down the bar. If the bar is met, what is the problem? I believe that their submission in that regard also did not address it. Coming to the state of Kedarkhand, Your Lordships, first of all, it is pari materia with the Act of Uttarakhand. And secondly, Your Lordship, by repealing all the personal laws, they are not in a sense bringing a uniform civil code. They have just whitewashed it by removing all personal law. And now no Hindu, no Muslim, no Parsi, no Jew, no Christian can participate or can continue professing certain aspects of their religion because they have all been repealed. Now all they can practice is one uniform civil code. Your lordships, they have also, the state of Uttarakhand is saying it is in the interest of national integration. It is only one state that has enacted this. Now we have the situation where one state follows a uniform civil code while the rest of the country does not. How is this promoting national integration? Again, your lordships, I think they have misread the intent of Article 44. It says that the state shall endeavor to secure for the citizens a uniform civil code throughout the territory. It is our humble submission, your lordships, that this can only refer, the state under Article 44 can only refer to the government of India or the Parliament of India because they alone have the authority to enforce something throughout the territory of India. Your lordships, they have also said that they have enacted this law to bring it on an equal footing with for all religions. But can we say that we are bringing everyone on an equal footing by taking away everything and saying that now nobody has anything? That would be a very unfair situation. Your lordships, they have also contested that the UCC now grants rights to tribes.
State religious spectator, when you, in the name of religious belief, keep on violating the rights, otherwise conferred under the Constitution.
I beg your pardon, Motion.
Can you expect the state to be a mute spectator when in the name of belief you keep on violating the rights of a party?
No, Your Lordship, exactly what we had contended.
Should the state not step in and prevent that kind of abuse?
Indeed, Your Lordship, they also brought up the idea of social welfare and reform. Your Lordship, they could have reformed these aspects of the personal law if the state of Kedarkhand felt. Your Lordship, it is our humble submission, they did not reform the personal law. They just took all of personal law out at once with one go without any logic or reasoning. What they should not have done, as Your Lordships rightly pointed out, they have capriciously done it. They have repealed everything and said now this is a uniform code. Your Lordship, the term itself is uniform civil code. It does not say a common civil code. It does not say one particular civil code that will apply to the entire nation. Your Lordship, it tells the government that we must act in a manner that eventually anyone, even following personal law, will be subject to the same basic ground rules. There should not be any variation on those terms, on those most essential features that, for example, the fundamental rights.
Coming in a way of you worshipping the deity of your choice.
Indeed, not your lordship.
Place of your worship, place of your choice, not coming in that.
Indeed, your lordship, but is it?
On a non-temporal basis, then brought in. What is wrong with that?
Your lordship, it is wrong because if there are aspects of my religion which do not offend the fundamental rights, which do not offend public order, which do not affect public constitutional morality or public health, then I should have been allowed to continue with this. Why have those also been taken out? Although yes, the state is not saying I cannot go to a temple or a church, but why am I not allowed to continue with my personal law, the Hindu law or the Muslim or the Christian law, if the aspects are not violating any of those guarantees under 25? Your lordships also, they talked about tribals, but they have failed to note that the uniform civil code that they have enacted does not apply to tribal communities. So why are they arguing on the grounds that tribal communities are also being reformed when the act itself does not cover those tribal communities? Your lordships, these are our humble submissions. Much obliged, your lordships.
Your Lordships, before we go into the survey buttons, I would like to point out one thing about them, that is jurisdiction. That is, Your Lordship, their jurisdiction says only Article 32. If you are telling only Article 32 and is not meet state and religious communities parties, you left out the parties here, but then you're coming here to rebut. So here you have conveniently, whenever you want, you left out the parties, whenever you want, you've taken the parties. Second point, Your Lordship, the petitioners are just throwing statements. The council once in the beginning told that Muslim women are not very literate and they are not very aware about their rights. What is your source of telling that all Muslim women are not literate? Your Lordship, also now coming to the sarjabats, they say that khula requires the consent of the man. Your Lordship, that is not true. In the case of XX and YY, the state of Kerala held that we declare that the right to terminate the marriage at the instance of a Muslim wife is absolute and does not depend upon the consent of the man. So your khula is given to the woman and it's her right alone. It does not depend upon the consent. Your Lordship also...
But she loses her right to receive a dowry, her dower at that stage. She is not entitled to, if she offers a khula, she doesn't get any benefit after that.
Your Lordship, the man has to, however, definitely pay her maintenance under Section 125 of CRPC. So she is not...
As a khula by itself.
She is definitely paying the little consideration to him because of the leading hand. Your Lordship, also the petitioners contend that the man will pronounce talaq whenever he wants on his fancies and whatever. Your Lordship, here the man is at the losing side in the khula because if he has to remarry, he has to pay mahar to another woman. So he is losing here. You can't just throw statement telling that he will pronounce talaq whenever he wants. Your Lordship, also they say 90 days of time is not enough. Our mediation courses are trying to finish the mediation within certain period of 60 days and all, and 90 days there is not enough. Your Lordship, also their contention about the live-in relationship, they first go on to say that live-in relationship being registered is wrong. Later they say that live-in relationship should be presumed under the marriage, basing their contention on a case of D. Veluswamy. Now D. Veluswamy's one condition says that they should hold akin to the spouses in the society. Now you in the society are holding each other as spouses according to the condition of D. Veluswamy for you to be a valid live-in relationship, but then in the other question they say that it should not be registered. The petitioners here are not clear with their contentions. They do not know what they are saying. They are contradicting their own selves, Your Lordship. Much obliged. And also Uttarakhand is not parametry with Kedarkhand. It is not written anywhere. I do not know where they source that from. So,
Yes, okay.
Thank you, Petitioner. Thank you, Respondents. A sincere thank you, Honorable Bench. Nice and patience shown by the bench is duly and sincerely appealed. Your Lordships are